All right, I am going to move along because we've got a lot to cover off on this morning. And the Law Society of the Northern Territory late last week said it was disappointed and concerned at the media commentary over recent weeks concerning the decision by the Northern Territory Supreme Court to grant bail to a young defendant to attend a funeral in a remote community. Now, Society President Mr 𝐸𝐿 𝐄𝐧𝐝 said it is imperative that the media and others, including politicians who comment publicly on such matters, take utmost care to ensure the accuracy of their commentary. Now, the comments followed a 4-page statement which was issued by the Chief Justice of the Supreme Court in response to public commentary concerning the granting of bail to the teenager 10 days ago. Chief, it seems to me the Law Society is concerned by commentary around the granting of bail to that youth involved in an incident which saw the baby's skull fractured. Now, we know that. Obviously, the Chief Justice also issuing that statement about these considerations required when determining whether to grant compassionate bail. Has this made you any less concerned that the teen was granted bail to attend a funeral at a cost of more than $7,000, or has it changed your mind on your comments you've made?
Oh, no, absolutely not, Katie. And again, the community was furious and continue to be questioning why this happened. Now, I undertook last week to go away and do some further work on this, and that is still ongoing, and I will absolutely let your listeners know if I can get to the bottom of whether or not this is normal practice, whether or not this money has been spent before. Certainly, the Chief Justice putting out a statement was highly unusual, and he flagged a couple of areas which raised our eyebrows around what further work we can do to strengthen the law. So to that extent, it was useful because we can now look at whether we need to tighten discretion. But I think it also defies or beggars belief. You know, the Chief Justice made a comment in his statement about there needing to be that other jurisdictions need the judges to have a high degree of confidence. And I just sort of got me thinking, well, we can strengthen the law to make it say judges have to have a high degree of confidence, but surely they've got to have a degree of confidence before they make the decision.
I'll take our listeners through that, because in the statement, as you touched on there, he said there is no provision in the Northern Territory legislation requiring that bail must not be granted to a youth unless the court has a high degree of confidence. Now, the young person, so a high degree of confidence that the young person will not commit a further offence while on bail. So I would have thought the same thing, right? I would have thought that you're not actually granting bail unless you do have a high degree of confidence that they're not going to commit a further offence while on bail. Unfortunately, we seem to see that time and time again in the Northern Territory. Very often we receive press releases from the Northern Territory Police. Somebody's been charged, a youth's been charged. They're also being charged with breaching bail. So are you now looking at strengthening this legislation? Is that something that needs to be tightened up?
Yeah, absolutely. So we're already doing a rewrite of the Youth Justice Act, so that is already on foot, but we'll now look at this clause and see whether that's required. But at the end of the day, I'm with you, Katie. I would have thought before the judge makes any decision around bail, they have to have a degree of confidence that they're not going to go on to offend. And as far as I'm concerned, the criteria that was outlined in the statement showed me all the reasons why you wouldn't grant that person bail, not the reasons why you would.
Have you met with the Chief Justice about this?
No, I haven't, but as appropriate, the Attorney General has. And, you know, that meeting needs to be a private meeting, between the two arms, and that's important. But at the end of the day, I'll make sure we strengthen the law if that's what is required. I'll make sure that we set a standard within the agencies to make sure that we are not just blindly, paying for things. So there's a lot of work that needs to be done because this hasn't been challenged before and it's not well understood. So we're still working through it.
So just on the funeral cost and whether that has happened before. You mentioned that you've met with the department. Has it happened before?
Yeah, so it's unclear. This is quite an unusual situation in that corrections could have just said, yep, all right, we'll bail the youth for the day. They decided not to because it was too high risk and they didn't have the resources. So that then meant because the territory was the parent, because the child is under the care and protection, the territory has to act like the parent.
Yeah.
And so I think for me, there's broader questions around, and as parents listening right now, as parents, we all have to draw lines in the sand about what we can do do for our kids, how much we can afford. And so I don't necessarily think that going forward, just because the Territory is quote unquote the parent, means that the Territory has to take extreme risk and extreme cost to facilitate something. Now, there are plenty of people who miss funerals, including your listeners, who decide that they can't afford to go into state for the funeral, or the children can't come with them. So, we have to have compassion in these situations, but also there's a realism that comes for ordinary parents. There has to be a realism that comes for the Territory when it's a parent too.
Okay, so it does sound as though you're seeking some further information from the department still. I'll be very interested to see what comes back there. It also looks like, or sounds like, you are looking at this part of, this provision, or there being no provision in the Northern Territory legislation requiring that bail must not be granted to a youth unless the court has got a high degree of confidence. So is there the possibility here that your government's going to change that legislation?
Yeah, definitely. It's certainly in the mix now, Katie, and we're just working through that now, and our rewrite of the Youth Justice Act is something we are really looking forward to, as I'm sure your listeners are as well. So, we've done our reducing crime package with Declan's Law, knife crime, nuisance public drinking, minimum mandatory sentencing for assaults on workers, a whole range of other things, and we've always said there's more work to do. Last Parliament, we gave police better powers to enter premises, so that work's ongoing, and we'll just keep working at it until we get it right.
On the Youth Justice Act, now somebody, listener did get in contact with us and raise with us Section 64A of the Youth Justice Act. Now, this section says Youth Justice Court may dismiss charges. So, as 64A Section 1, subject to subsection 2, the Youth Justice Act may at any stage of the proceedings against a youth in respect of an offence dismiss the charge in respect of the offence, whether or not the court finds the charge proven against the youth. Now, I am not a legal expert. I'm certainly not professing to know the Youth Justice Act inside and out, but from the outset of that, me reading that, I read that to mean that at any point the court can dismiss charges which the police have laid against a youth that could be very serious.
Yeah, and our legislation is way too broad. So Queensland and New South Wales do have very similar provisions, but they are a bit tighter. So this Section 64A will be part of the Youth Justice rewrite that we're doing, and we'll look at strengthening that. But, I just want to go to your point perhaps in your opener, Katie, where we've got the opposition leader coming out swinging on our bail laws. Section 68A is a Labor construct, and we've got
So how long's that section of it been in place?
Well, probably since the new Youth Justice Act under Labor, when they did the big rewrite quite a few years ago, where all of the bail laws were weakened and all of that other stuff. So I think Labor's kidding themselves if they want to have a crack at us for bail laws. We've gone a long way, and there's more to go. But I tell you what, under Labor, people were getting bailed left, right and centre.
So can I just delve into this a bit more deeply? At this point in time, can the court dismiss any charges that have been laid against a youth if they see fit?
Look, I won't answer that, Katie, only because I don't exactly know the answer. It certainly reads that way, and it's certainly been told to me that it is too broad. Queensland, as I said, Queensland and New South Wales do have similar provisions. Can we make it tighter? Absolutely. So I'm throwing that section into the Youth Justice Act rewrite so that the right people can look at it. So that'll be police, children and families, Attorney General and Justice, and corrections. They will look at it and come back to us with what we need to do that's better. And I'll try get an answer to you on that so you can let your listeners know.
So when are you expecting that rewrite of the Youth Justice Act is going to sort of be ready to go?
Yeah, I think we're looking to mid-year. So obviously if it can be done sooner, we absolutely will, but we want it to be really comprehensive as well. And because it touches on a number of agencies, we've really pulled together a team to be able to look at it. And I've been able to put in a lot from, say, Strikeforce Trident, for example, gave me some on-the-ground practical measures they'd like to see in it. So that's in the mix. And it's been a really collaborative frontline initiative, and we're really looking forward to getting that through.
Look, I know some people listening will be thinking, Wolfie, putting kids in jail is not the answer. Charging kids is not the answer. There needs to be intervention early. You need to stop them before they get on this track. And look,
sure, that's all true.
It is, but at the end of the day, if there are young people who are committing serious offences, there also needs to be a consequence to those offences.
And you have to weigh up their rights versus the community's right to be safe, and that is always a balancing act. But that's exactly what a justice system is for. If you have a young person that shows continual disregard for the law, is exhibiting a risk to the community, they have to be dealt with in an environment that means everyone else can go about their day safely. And that's the brutality of the system. But if you're doing the right thing, you'll never have a problem. So that's my message to everyone. Just follow the law.
It sounds as though everything is on the table when it comes to the Youth Justice Act and it being rewritten, not just the age of criminal responsibility.
Oh, absolutely. So age of criminal responsibility is done. The Youth Justice rewrite is looking at all sorts of things that, Labor unwound a lot of things, Katie, and, we don't have all the answers yet because as we come across something, just like last week, it raises up new issues that we need to fix. So the idea behind the rewrite is to pull all the right agencies together to get their feedback on how that act that Labor did has been working and how we can strengthen it to better align to community expectations. So we're very keen to get it done. I don't want to rush it, but I don't want it to drag on. So I would expect by mid-year we're good to go.